Hi, welcome to Hildebrand Law Firm. We're so excited to meet you and help you achieve your estate planning goals. In this short introductory video, Attorney Matt Kaplan and I will give you a quick overview of all the essential information you need to start protecting your today and your future. Hi there, I'm Attorney Kirsten Hildebrand.
And I'm Attorney Matt Kaplan.
And we are here today because we believe it is very important for you to have good education and good information before you make decisions that will affect your end of life.
Yes,
is that right?
I agree. And what we're intending to do is we're intending to take our normal workshop that would usually take about an hour and a half, and we are going to scrunch it down to about 20 minutes.
We do encourage you to still watch that workshop. I think it is excellent, and I think it does provide you with additional information. But for purposes of making sure that you're prepared for the vision meeting, which is going to happen after this video is over, we want to make sure that you have a good working knowledge of some very important laws. There's three main threats that we would like to address with you today. The first threat is when something goes wrong with your physical body. When that happens, not if, sadly, but when that happens, we want to make sure that you have the very best documents in place that will handle that. And the first one is a power of attorney for healthcare. So a power of attorney for healthcare, where do you normally get those from?
Most people, I would say, get them from the doctor or the hospital, right?
Exactly. Are they lawyers too?
No.
Okay, so that's the problem. The problem is you're being handed a legal document from a healthcare entity. I would never give you something from Hildebrand Law Firm that would be, say, directions for getting a surgery done on your leg. That would never happen.
No.
And so in the same sense, it is very important to understand that the healthcare power of attorney document is like a God power. It essentially gives somebody the ability to act on your behalf. Also, if you don't have a healthcare power of attorney, there are some serious risks that come with that. And one of them is
a guardianship. And to give a brief overview of what a guardianship is, it is a thing that we file with the court to get an individual appointed on behalf of someone else to make these healthcare decisions for them. Now, with courts and lawyers being involved, guess what, Kirsten? It can get very expensive.
Yes, it gets very expensive and very quickly because you have to hire a psychologist to do an evaluation. There's a guardian ad litem that's appointed to represent the court with their investigation. There's advocacy counsel that is appointed in order to make sure that the person who you're trying to obtain guardianship over is legally represented independently of the guardian ad litem. And then there's the lawyers representing the various parties. There's hearings. There's all kinds of investigations that occur. And so I call these, it easily can get between $10,000, $20,000. And who pays for that, Matt? The state of Wisconsin pays for it, right?
No, of course not. You pay for it.
That's right. And so that's why having a well-written power of attorney for healthcare that addresses guardianship, that also gives your specific instructions under various circumstances is just extremely important. The second document that happens when you are no longer able to make decisions for yourself is the
power of attorney for finances. And to give a brief overview of what this is the document that allows someone who you trust to step into your shoes. And the reason it's called a power of attorney, they are granted the power that an attorney would have. They become you. They can sign documents on your behalf, participate in things on your behalf, go to your banks on your behalf, taxes. We have a slew of things. We have about 11 pages of things that are listed in our document, of all the specific things someone can do. And the statute is very particular, Kirsten. It says, you can list these things, but here's a set of things where if you don't list them, you can't do them. And the reason that this document is so important is because, again, like what you mentioned, Kirsten, it avoids the need for a guardianship.
That's exactly right. And so making sure that you have that in place. Now, there's two different types of ways that the document can go into play. Either, number one, it can be springing, which means that it is only upon your incapacity, or number two, it can be immediate. Most people don't realize that they have that choice. And so when they come in with power of attorney for finances documents, they don't realize that they just gave all of this power away without them even having some sort of requirement for incapacity. So we do want to make sure that you get that choice. All right, so those are the things that happen sort of generally that need to be addressed when you are no longer able to make decisions for yourself. Now, let's give a couple of definitions for sort of the next issue, which is what happens when somebody is in need of getting into nursing home care.
Right. And so there's a lot of things that have to happen when someone needs nursing home care. The biggest thing that we try to avoid is the cost. Nursing homes are incredibly expensive. This year in 2025 in the state of Wisconsin, the average cost of a nursing home is excess of $10,371.
That's a lot. Per month?
Per month.
Per month.
Incredible.
It is. And so there's a good news, and that is that you have been paying towards that bill by paying your taxes into the Medicaid program if you've been drawing a paycheck. So I started drawing a paycheck when I was 13 years old. So I have literally been paying into Medicaid since that point in time. I would like to get that benefit.
Right.
And have my my long-term care costs covered by that benefit. But it's tricky, isn't it, Matt?
It is. There's a lot of hoops you need to jump through. There's a lot of ways that you can qualify for Medicaid, but there's two main ways. You have to functionally qualify. That means you have to have the need. You have to fail 2 out of 6 activities of daily living or have dementia. And then once that checkbox is checked, the second one, which is the hardest one, is you have to financially qualify. And Kirsten, financial qualification for a single person is the easiest thing in the world. How much can you have?
Well, you can have $2,000.
For a married couple, it gets a heck of a lot more complicated, but yeah, $2,000. And this is where things get a little tricky. So if you're taking notes, please write this down. $2,000 in countable assets.
So that's where you get all kinds of interesting ways that we can assist you, because countable assets can be classified in ways, or rather the assets that are not going to be counted, but can be classified in different ways to allow for you to actually still have a lot of assets, but then also qualify for Medicaid.
Right, and I have a lot of family members who come to me and say, well, $2,000, my house is worth $300,000. How the heck is that going to work? And Medicaid has a solution because, the state of Wisconsin loves all of us. They say, we will not force you to sell your home in order to pay for your care. Which sounds really nice, doesn't it, Kirsten?
It certainly does, and it was nice until 2014 when the estate recovery program went into place in Wisconsin. It's actually mandated by the federal law, so if you're receiving federal funding for Medicaid, which Wisconsin is, then they have to try to recover those funds from you. So if your house is $300,000, as Matt was saying, and you go into long-term care, they're not going to force you to sell your house, but they will put a lien on the property, even if it's a transfer on death. So a lot of people think, oh, I have transfer on death, that'll just happen. No, it will not just happen. There will be a lien placed on the property or a claim against that estate, and then that which you have spent on Medicaid will then be paid back to the state from that. We've had many, many situations where the entire inheritance has been completely wiped out because of the estate recovery program coming and getting those funds.
So your house, you won't be forced to sell it while you're alive, and the reason is they just take it from you after you pass away.
Right.
And so I mentioned countable assets earlier, Kirsten, and there's a bunch of exceptions to what is not seen as a countable asset, what is seen as a countable asset. But one of my favorite things and where we come into play is what is not going to be seen as a countable asset, and that is any asset held by your irrevocable trust. Not just any irrevocable trust, there's so many different types. The specific type of Medicaid compliant asset protection trust is a type of irrevocable trust that allows you to hold your asset, you maintain full control over it, but it will not be seen as a countable asset for nursing home purposes.
So let's back up just a little bit and let's talk about your little red wagon. Did you ever have a little red wagon when you were growing up? I did, and I loved it, and it was mine. And I would put my Kelly doll in here, and I would just go around the yard and pick up all of those sticks and stones and things like that I wanted in it. So a trust is like a little red wagon. It is yours. You develop it, and you put your instruction manual on the handle, and you designate who is the next trustee after you. And so then when you're no longer able to wheel the wagon around for whatever reason, then the next trustee picks it up reads the manual and then does exactly what you say and transfers the assets after you pass away to your beneficiaries. So this is very, very important because it avoids probate. Now, very quickly, probate is a legal process that says the state of Wisconsin is doing everything that normally you would have in your rule book here. This is anywhere from 5 to 20% of the gross value of your estate that goes into probate. So it's expensive, it's long, and it ties everything up. Whereas the trust is easy and it's way less expensive. Now, I just want to say a lot of people think that if you have a will, you're not going into probate. But in fact, the opposite is true. A will is instructions to the court. It's instructions to the probate court about what it is that you want, but then the probate court oversees the administration of the will. So now let's hook back into what Matt was talking about. There are two main types of trust that we work with here at Hildebrand Law Firm. The first one is the revocable trust, and this is an open box. As you can see here, it's an open box. So then when you put things inside of the open box, you are no longer having them have to go into probate. So that's fantastic. So you could put your house in there, your bank accounts, your everything that you own, anything that's an asset, the farm up north, whatever it is that your family might have in terms of legacy properties, all of that can go in here. That's great news because it gets you out of probate. However, the irrevocable trust has the additional benefit of being the closed box. So this is the one that has asset protection for you during your lifetime. And so this one, if you were to put your house in here, now after how many years, Matt?
5 years.
After a 5-year look back, anything that is inside of this irrevocable trust is now no longer considered to be an available asset, a countable asset. So you could literally have as much money as you want in here and as many properties as you want in here. And as an individual, if you had $2,000 outside of the irrevocable trust, you would qualify for Medicaid benefits.
You sure will. And the main reason that a lot of folks come to us and say that they want to do this, and our goal, and Kirsten and I talk about this all the time, our goal is not to say, let's put every dime you have inside of that trust, and then if you ever need long-term care, you're going to qualify for Medicaid day one. That's not really our goal. Our goal is more so, we want to take your house, which you've worked hard for, maybe that place up north that you inherited, maybe that farmland, that hunting land, maybe that investment account or some stocks that you inherited. We want to have the things that you want to keep in your family stay within the family. So we always recommend if there are any assets that you have that you say, well, if I got sick and was forced to sell this to go to a nursing home, would that affect my family? Would I be devastated about that? And if the answer to the question is yes, then we just highly recommend putting it in an irrevocable trust. And now, just real quick, when we say put it in an irrevocable trust, people always ask us, well, how the heck does that actually work? How does anything go into an irrevocable trust or a revocable trust? It's actually very simple. For your properties, we do it for you.
That's exactly right. It's a legal process where we transfer the asset into the irrevocable trust once it has been established.
And what does it look like? It's just a quick claim deed, especially if it's a property that we draft up for you. All you need to do is sign it. Then we sign and notarize it, and then we file it with the respective county. And then once it's recorded, we send the deed back to you. So now, as of the moment you sign that document, your home is in one of these respective trusts and is safe as of that point. For your other assets, if you have a financial advisor, we work with them to make sure that the financial advisor is on board. For things such as bank accounts, we'll just counsel you about how to go to the bank and how to get everything switched over. It is actually a remarkably simple process. I remember the first time I did it when I was helping out my mom get her trust set up. It was the first time I did it in practice, and it was way too simple, actually. I was expecting it to be a little bit more complicated, but it was Really simple.
especially compared to a probate.
For
and
sure.
That's why. So, and I think you said something very important, and that is we are here for you. We are here to listen to what your goals are, what your desires are with respect to your assets, and then to come together and come up with a plan that really is reflective of what your wishes are. Sometimes we have clients that come in and they say, honestly, we really don't have beneficiaries. We think that it's important to not have our stuff go into probate so that our beneficiaries who are maybe charities or more distant relatives or somebody like that, we don't want them to go through a probate. So we'll put everything in revocable trust. But if we need that money, we want to have access to it. So then somebody would land on just getting a revocable trust. Other people feel like, I really want to make sure that my beneficiaries get these assets and it doesn't get chewed up. And in fact, it happened with my parents. They had all of their money that got spent on situations related to nursing home, and we do not want that to happen. And so then you would be looking at putting whatever assets you want into the irrevocable trusting. You get to choose what that would look like. But I do call this also the inheritance trust because it does really guarantee that inheritance. It is also very important to get it done. So that is why we're delighted that you are here, that you heard all of this. Any questions that you have, we are going to come in, and now we're going to start the second step of this 4-step educational process, which is to actually talk about these concepts specifically related to your goals and your assets. Thank you so much, and we look forward to working with you.